Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Okay, let's unpack this. Have you ever imagined the high stakes involved when a company believes its innovative creation has been copied? It's far more than just a simple accusation. It's a detailed, often prolonged legal battle that can really define industries. Today, we're diving deep into a fascinating case from the High Court of Himachal Pradesh. It's a patent infringement dispute that shines a bright light on the intricate world of intellectual property law in India.
What's truly fascinating here is how a single legal decision, even an interim one like this, can illuminate crucial principles. Things like patent validity, the subtle nuances of what actually constitutes infringement, and even that delicate balance courts must strike, between protecting private innovation and serving the broader public interest. We'll be looking at the case of SML Limited versus Mohan Company, a battle over an agricultural composition that holds significant implications for how patents are both protected and challenged within the Indian legal system.
Exactly. So our mission for this deep dive is to guide you through this complex legal landscape. We're aiming to transform dense court documents, highly technical specifics, into clear, actionable insights. You'll gain a thorough understanding of the core facts, the ingenious arguments put forth by both sides, and crucially, how the court ultimately decided this pivotal interim injunction. Get ready for some surprising facts and definitely a few aha moments that will clarify just how these high-stakes disputes unfold. To truly grasp the gravity of what unfolded in this case, we need to begin with the fundamentals. Who are central players? What precisely is at stake with this patented invention? And how did this entire legal drama evolve over time to reach such a crucial interim decision? All right, first up, our primary player, the plaintiff in this lawsuit, is SML Limited. Picture them as a driving force in agricultural research, deeply committed to developing advanced solutions for crop nutrition and protection. SML Limited is the proud owner of Indian patent number 282092. And this isn't a new patent. It was officially granted back on March 30th, 2017. It's for something quite specific, an agricultural composition.
And this isn't just any generic fertilizer formulation, not at all. The heart of this invention, as meticulously described in the patent, is a very precise fertilizer composition. Its key ingredients include sulfur, present in a significant range of 30% to 87% by weight, zinc oxide from 3% to 25% by weight, and an agrochemically acceptable excipient that's essentially a carrier or filler material in a range of 3% to 65% by weight of the total composition. But the truly distinguishing features, the ones central to the patent claims and crucial for its effectiveness, they revolve around its physical form, and more critically, its particle sizes.
And that's where the unique engineering, the clever part of this product comes into play. This composition isn't just a powder. It has to be in either microgranule or broadcast granule form. And the particle sizes are incredibly specific. At least 90% of the individual particles making up the composition must fall within the range of 0.1 microns to 50 microns. That's tiny. And then for the broadcast granules themselves, the larger pieces you'd actually spread on a field, they need to be precisely between 0.75 millimeters and 5 millimeters. These exact ranges, particularly for the particle and granule sizes, are absolutely critical for the patent's claims 11 and 12. Those are the very heart of this infringement dispute. And SML Limited wasn't just sitting on this patent, right? They launched their commercial product based on this invention, which they branded Techno-Z back in August 2018.
Right. And on the opposing side, we have Mohan Company, listed as defendant number 1, and another unnamed defendant number 2. SML Limited accused both of infringement. These are the entities alleged to be marketing, selling, and manufacturing a product called Aladdin. The very essence of SML Limited's lawsuit rests on the allegation that Aladdin directly infringes upon those very specific claims 11 and 12 of their patent. The ones detailing the precise composition and those critical particle and granule sizes we just talked about.
Yeah. Presiding over this complex and highly technical case in the High Court of Himachal Pradesh in Shimla was the Honorable Mr. Justice Sandeep Sharma. His judgment would determine the fate of this interim injunction. And also, playing a pivotal role, and we'll definitely delve into this much more, was Dr. Phul Kumar Patanjali. He was a chemical analysis expert whose independent affidavit provided crucial technical evidence for SML Limited, the plaintiff.
Yes, and it's also important to note that this wasn't the first time SML's patent faced scrutiny. Other key entities, particularly the Haryana Pesticide Manufacturers Association, or HPMA, of which defendant number 2 is a member, had previously filed oppositions against SML's patent. So this pre-existing history of challenges would become quite relevant in understanding the arguments presented in court during this specific infringement case. There's a background here.
Right, context is key. So this wasn't a sudden legal skirmish or a quick accusation. It was more like a carefully choreographed legal dance spanning years, with each step building upon the last. Let's walk through the timeline, because it truly sets the stage for the depth and robustness of this battle. It all began way back on March 10th, 2011. That's when SML Limited filed what would become their 3rd patent application for this invention. Just for a bit of historical context, they actually had 2 earlier applications for what was essentially the same invention. One was eventually withdrawn, and another was actually granted as IN 282429. That specific earlier patent would later become a point of contention for the defendants.
That historical context is crucial. When a patent goes through multiple applications or iterations, it can sometimes raise questions. Questions about evergreening, an alleged attempt to extend a monopoly. However, for SML, this pre-grant history also signifies their persistent efforts to secure intellectual property protection for their innovation. It shows a company committed to patenting this invention. And that kind of persistence, well, it often strengthens a patent's standing in court.
Absolutely. So fast forward a few years to March 30, 2017. This was a truly significant day because Indian patent number 282092, what we're now calling the suit patent, was officially granted to SML Limited for a term of 20 years. And what's particularly noteworthy is that on that very same day, 2 pre-grant oppositions against it were dismissed. Think of these as early challenges from third parties trying to prevent the patent from even being granted in the first place.
Indeed. Surviving pre-grant opposition sends a powerful signal. It means the patent has already passed an initial independent review process by patent examiners, and it has overcome objections from interested parties. This grants it a certain, presumption of validity in the eyes of the law, a factor that would heavily influence the court's later considerations in this infringement case.
Then, on September 4th, 2018, SML Limited formally asserted its exclusive rights over the patented product, clearly signaling their intent to defend their innovation against any potential infringers. Moving even closer to the present, on June 16, 2023, 2 post-grant oppositions against the patent were also dismissed. So this meant the patent had now survived not only initial challenges before it was granted, but also subsequent challenges after it had been enforced. Quite resilient.
Exactly. This repeated success in defending against oppositions really reinforces the argument for the patent's inherent validity. It makes it significantly harder for later challenges, especially those raised by an accused infringer in a lawsuit, to be dismissed as mere afterthoughts or, groundless claims. It demonstrates a patent that has consistently withstood scrutiny over time.
Okay, so just over a month later, on July 24, 2023, the High Court of Himachal Pradesh granted an interim injunction. That's essentially a temporary restraining order, right? Against Mohan Company and the other defendant, preventing them from continuing to allegedly infringe SML's patent rights. This was an initial urgent measure taken by the court.
Yes. This interim injunction is a critical first step for a patentee seeking to halt perceived infringement. It signifies that the court, at a very preliminary stage, saw sufficient immediate merit in SML's case to issue an urgent order, even before a full hearing of all arguments. It suggests a preliminary finding of both a strong prima facie case, meaning at first glance there appears to be infringement and potential irreparable harm to SML if the alleged copying were allowed to continue.
Then, in a move to speed things up, an order was issued on September 30, 2024, directing the High Court to decide the main interim application within 4 weeks. This put a clear, expedited timeline on the decision-making process for this critical temporary order.
This kind of acceleration is pretty common in intellectual property cases, especially where ongoing infringement could cause significant, irreversible market damage to the patent holder. The courts recognize the need for swift action to protect an innovator's investment and competitive edge, particularly when a patent has already demonstrated some resilience through prior challenges like this one had. It reflects the urgency felt by the patentee to stop what they believe is illegal competition. Then on November 27, 2024, a really crucial piece of evidence came into play. Dr. Phul Kumar Patanjali, the chemical analysis expert we mentioned, he prepared his technical affidavit, and it unequivocally stated that the defendant's product Aladdin prima facie infringed claims 11 and 12 of the suit patent. This was a direct, expert scientific assessment forming a cornerstone of SML's case. Absolutely. The role of expert testimony, like Dr. Patanjali's, cannot be overstated in patent cases. These are inherently highly technical disputes, you see, and the court often relies heavily on specialized scientific analysis to determine if a product truly falls within the precise scope of a patent's claims. This affidavit, providing a detailed chemical comparison, was a foundational piece of SML's infringement argument. It gave the court a solid scientific basis for its potential findings.
Okay, so after all the arguments from both sides were heard, all the evidence presented, the High Court of Himachal Pradesh reserved its order on the interim injunction application on April 25, 2025. This is that stage where the judge retreats to meticulously weigh all the evidence, the legal arguments, the precedents, before rendering a decision.
That period where an order is reserved is always a tense one for the parties involved. Definitely. It signifies that all parties have had their say, and the court is now meticulously reviewing the complex interplay of technical facts, legal precedents, statutory interpretations, before rendering its decision. It's a moment of deep deliberation.
And finally, the moment of truth arrived on June 6, 2025. The High Court, through Justice Sandeep Sharma, decided the case, and they confirmed the ex parte ad interim injunction that had initially been granted. This was a significant win for SML Limited at this interim stage of the legal battle. It effectively kept Aladdin off the market, at least for now.
Yes, this confirmation is a powerful signal. It means the initial temporary order was upheld after a more thorough adversarial hearing, which strengthens SML's position considerably, at least for the interim period until the full trial on the merits. It indicates the court found SML's case compelling enough to continue the injunction.
Right, and just over a month later, on July 10, 2025, the matter was listed for the framing of issues and further proceedings for the full trial. So this signifies that while SML secured the interim injunction, the main battle for a permanent resolution, a final judgment on infringement and validity, is still very much ahead. The court is now preparing for the next major phase of litigation.
So if we connect this detailed timeline to the bigger picture, you can see this isn't a simple copycat dispute decided overnight. Not at all. It's a carefully unfolding legal battle. The patent itself had gone through multiple challenges and validations even before this infringement suit began. This timeline truly shows a patent that's been robustly defended from the start, indicating a long, consistent history of intellectual property protection efforts by SML.
Okay, so with the scene set and the timeline clear, what did the court actually need to figure out? This wasn't just a quick guilty or not guilty decision, especially not at this stage. For this interim injunction, the judge had to grapple with three fundamental questions, each carrying significant legal weight. Let's unpack these core legal issues first, and then we'll dive into how each side argued their case. The very first critical question before the court was this. Is the defendant's product, Aladdin, at first glance, infringing claims 11 and 12 of SML's Indian patent NAL 282092? This is known as a prima facie assessment. Think of it as looking for a strong initial indication of infringement, enough to justify a temporary halt without conducting a full, exhaustive trial. The court isn't making a final determination of guilt at this stage, but rather assessing the likelihood of success if the case were to proceed.
Right. And the second question, equally crucial, went to the very heart of the patent itself. Had the defendant presented a strong, believable argument that SML's patent was actually invalid, a credible challenge, as the court puts it, this challenge would need to be grounded in specific sections of the Patents Act, 1970. For example, Section 3D deals with new forms of known substances, requiring them to show enhanced efficacy to be patentable. And Section 2.1 is about whether an invention possesses an inventive step, meaning it's not obvious to a skilled person in the field. Without a credible, substantial challenge to validity, the patent, having been granted and survived opposition, holds a strong position.
And finally, based on the answers to those first two questions, was there prima facie infringement, and was the patent credibly challenged? The court had to decide if SML Limited was indeed entitled to this temporary restraining order, this interim injunction. Again, this isn't a final judgment on the entire case, but a critical, urgent step. It's designed to prevent ongoing harm to the patent holder while the full legal battle unfolds. It's about protecting rights until a definitive decision can be made down the line. Okay, now let's turn our attention to SML Limited's meticulously crafted case. They essentially argued for a powerful, exclusive monopoly firmly rooted in their granted patent, and asserted that Mohan Company was clearly violating this right by copying their invention.
SML began by firmly establishing its ownership of patent number 282092. This patent was originally granted after an assignment from Mr. Deepak Pranjavanda Shah, making SML its rightful and exclusive owner. And they didn't just stop at their Indian patent. They highlighted that the same invention had also been granted patents in 13 other countries globally. This kind of widespread international protection often serves as powerful circumstantial evidence, suggesting the invention's true novelty and inventive merit on a global scale. It implies that multiple patent offices worldwide recognized its unique qualities.
And they really leaned into Section 48 of the Patents Act 1970. This section is foundational to patent law in India because it explicitly grants the patentee, the owner of the patent, the exclusive right. The right to prevent others from making, using, selling, or importing the patented product in India without their express consent. SML stressed that this exclusive right is considered the highest form of monopoly in intellectual property law, underscoring the profound significance and legal weight of the rights they possessed and sought to protect.
Their argument for clear infringement by Aladdin was direct, precise, and highly technical. SML alleged that the defendant's product directly infringed upon their critical claims, 11 and 12, which, as we discussed, detailed the specific composition and particle sizes of their agricultural invention. This wasn't a vague accusation. It was a targeted claim based on very specific patent language.
Right, and this is precisely where Dr. Phul Kumar Patanjali's expert affidavit became absolutely central to SML's case. His independent chemical analysis of Aladdin provided what SML argued was concrete, undeniable evidence. He found that Aladdin contained 67.8% sulfur, which fell perfectly within SML's patented range of 30-87% as specified in Claim 11. It also had 22.7% zinc oxide, fitting comfortably within the 325% range of Claim 11, and 3.8% excipient, well within the 365% specified in SML's patent.
Furthermore, Dr. Patanjali's analysis confirmed that Aladdin was indeed in broadcast granule form, and that an astounding 100% of its granules fell between 4.75 millimeters and 4.75 millimeters, which is precisely within the 0.75 millimeter to 5 millimeter range specified in SML's Claim 12. Crucially, he also found that at least 90% of the individual particles were between 0.1 microns and 50 microns, just as outlined in SML's Claim 11. This highly detailed, almost forensic analysis of Aladdin's chemical composition and physical properties formed the bedrock of SML's infringement claim, providing a clear, you could say, chemical fingerprint match.
And SML even cleverly used the defendants' own marketing claims against them. They pointed out that Aladdin's product packaging brazenly boasted improved features over conventional micronutrient source and highlighted its water-dispersible nature. SML powerfully argued that this particular characteristic, water dispersibility, is a unique and key feature of their patented invention, emphasizing that Aladdin wasn't just a generic or prior art product, but an infringing copy that was actually claiming the very technical improvements their patent offered. It was like the defendant was inadvertently admitting to copying a unique aspect.
Yes, and SML's argument for robust patent validity wasn't just about their product's features. It was profoundly about the patent's historical journey and strong legal standing. They characterized their patent as an old patent, having been in force for 14 years out of this 20-year term. They argued that such a patent carries a powerful presumption of validity unless exceptionally strong, concrete evidence is presented to counter it. This places a significant burden of proof squarely on the party challenging its validity.
And they had a very strong track record to back that up. SML emphasized that their patent had already undergone detailed scrutiny and stood the test of multiple pre-grant and post-grant oppositions. They specifically highlighted that these oppositions included challenges from the HPMA, the Haryana Pesticide Manufacturers Association, of which defendant number 2 was a member. The fact that all of these prior challenges had been dismissed was a compelling point for SML. They further highlighted that no revocation petition had been filed by the defendants before the specific infringement suit, strongly suggesting that their current validity challenge was merely an afterthought, a desperate defensive maneuver rather than a genuine, long-standing belief in the patent's invalidity.
To further strengthen this crucial point, SML stressed the credible challenge standard. They argued that challenging patent validity, even at this interim stage, requires far more than just bare assertions or vague claims. It demands acceptable scientific material and expert evidence to back up those claims, not just mere averments. They cited well-established legal precedents like Bristol-Myers Squibb and Strix Limited to reinforce this high evidentiary bar for invalidity claims.
And on a crucial technical point, SML contended they had successfully overcome the often challenging hurdle of Section 3 of the Patents Act. This section often applies to new forms of known substances and mandates that for such an invention to be patentable, it must demonstrate a clear enhancement in efficacy over prior art. SML argued their patent demonstrably achieved this. They presented specific data from their experiments showing that treatment number 7, representing their patented composition, yielded a significantly higher yield compared to treatment number 15, identified as prior art.
Wow.
What's compelling here is that this higher yield was achieved even with reduced dosages of sulfur and zinc, strongly suggesting a synergistic effect where the combination works better than the sum of its parts. This was a critical aha moment. Yield improvement, even with less input, directly translated to enhanced efficacy.
Right. Now let's pivot to Mohan Company's counterarguments. They weren't just denying infringement. They were actively trying to cast serious doubt on the very foundation of SML's patent, and even the legitimacy of the legal proceedings themselves. Their strategy was multi-pronged, aiming to undermine SML's case from every angle.
They kicked off their defense by raising issues of delay and territorial jurisdiction. The defendants argued that their product, Aladdin, had been openly sold in the market since as early as 2020. They suggested that SML's alleged undue delay in seeking an injunction waiting years after their product was on the market should be a reason to deny any interim relief, especially without a chance for the defendants to file a full, detailed reply.
On the jurisdiction front, they launched a sharp attack. They claimed that the entire lawsuit was based on a single trap purchase, a strategically made by SML in Shimla, Himachal Pradesh, purely to create a jurisdictional link where none naturally existed for the defendants, or so they argued. Defendant number 2 also explicitly stated they weren't licensed to sell their product in Himachal Pradesh, further reinforcing their argument against the court's local jurisdiction.
They even brought in a procedural challenge, invoking Section 20B of the Code of Civil Procedure. They argued that SML had failed to seek the court's necessary leave to proceed against all defendants, particularly since some were located outside the court's specific territorial jurisdiction. This was an attempt to dismantle the very structure of the lawsuit and potentially have it dismissed on procedural grounds.
Okay, on the direct infringement claims, Mohan Company asserted that there was no infringement at all. They argued their product was distinct. Their main point hinged on the specific excipient used in Aladdin. They claimed their product uses bentonite, which they argued isn't explicitly listed in the patent's examples as an agrochemically acceptable excipient.
Their argument here was quite specific. SML, they contended, couldn't seek patent protection beyond what was precisely described and exemplified in its patent specifications. And since bentonite wasn't explicitly mentioned, it couldn't be covered by SML's claims. They also tried to create a direct contradiction. They asserted that SML's patent itself, in its background of invention section, admitted that sulfur zinc oxide compositions with bentonite are not water dispersible. They argued this directly contradicted SML's claim that water dispersibility was a unique patented feature and present in Aladdin, suggesting SML's own patent described a different non-infringing product if it contained bentonite.
A major thrust of their defense was to attack the patent's fundamental validity, arguing it was either already public knowledge, prior art, or lacked an inventive step. They claimed that the very proportions of sulfur and zinc oxide outlined in SML's claims 11 and 12 were actually admitted prior art by SML itself within the patent document. This would mean Aladdin was simply a known composition and thus couldn't be infringing anything novel or new.
And this is where their argument got really interesting and took on a significant public interest dimension. They strongly asserted that fertilizers are classified as essential commodities under India's Essential Commodities Act, or ECA. And, more importantly, the Fertilizer Control Order, or FCO, sets mandatory government standards for these products. For example, minimum percentages like 65% sulfur, 18% zinc, and granule sizes of 1/4 millimeter.
Right. So their powerful argument was that SML was essentially trying to patent a government-prescribed standard. If SML succeeded and enforced its patent, it would effectively mean that any company selling fertilizers that simply meet these FCO standards would automatically be infringing SML's patent. This, they argued, would severely impede competition, create an unfair monopoly over basic agricultural necessities, so as to go directly against public interest and undermine the legislature's intent behind the ECA, which is to ensure widespread availability of essential goods. It was a classic public good versus private right argument, really trying to leverage that angle.
They also brought up Section 64 of the Patents Act, challenging the patent's validity. By pointing out that FCO regulations, specifically those notifying standards for commercial trials, predated SML's patent filing date of March 10, 2011. They contended that if the FCO standards were already publicly disclosed and mandated, SML couldn't claim them as inventive or unique for patent protection.
Mohan Company also cited the case of Dhanpad Seth, arguing that a mere patent grant doesn't automatically guarantee an injunction. They stress that patent validity can and should be challenged at any stage, as allowed under Sections 107(1) and 64 of the Patents Act. They also conceded that the 6-year rule, the idea that a patent that has been around for at least 6 years carries a stronger presumption of validity, is a caution, not a rigid rule, referencing F. Hoffman LaRoche to support this flexibility.
Crucially, they argued that the legal principle of res judicata was inapplicable here. Res judicata basically means a matter that has been definitively decided by a court cannot be litigated again between the same parties. They claim that the previous oppositions filed by HPMA, of which defendant number 2 was a member, didn't preclude their current validity challenge. Because, they argued, opposition proceedings aren't considered a suit in the legal sense, and Section 11 of the CPC only applies between the same parties in 2 actual suits. It was a nuanced argument trying to open the door for their validity challenge despite prior dismissals.
They vigorously attacked the patent on the grounds of lacking an inventive step, invoking both Sections 3 as a 3 and 201. Under Section 3 they reiterated that SML's patent was merely a new form of a known substance, for instance, a change in particle size, but failed, in their view, to show the required enhanced efficacy over existing forms.
And to bolster this, they pointed to SML's own data within their patent specifications. They claimed that treatments 7 and 8, which included SML's claimed particle size, actually performed worse in some respects than treatments 1 through 3, which they argued represented prior art. They specifically contended that a mere 2–3% yield difference was not significant enough to qualify as truly enhanced efficacy. More profoundly, they argued that true efficacy should be proven by higher nutrient absorption by the plants, not just a marginal increase in yield, suggesting SML's data was insufficient.
And under Section 2.1, which requires a technical advance over existing knowledge or economic significance, they argued there was neither. They highlighted that sulfur, zinc oxide, and their combinations are well-known compounds in agriculture. Merely experimenting to find an optimal range of known components, they contended, is not inventive. It's just routine optimization. Furthermore, they asserted that achieving the desired particle size through standard milling techniques is a well-known routine method in the industry, and therefore not an inventive step deserving of patent protection.
The defendants also tried to discredit Dr. Patanjali's expert affidavit, which was such a pivotal piece of SML's case. They challenged his expertise, questioning why an organic chemistry expert was opining on inorganic fertilizers. A fair question, perhaps. They argued that courts shouldn't rely on untested expert opinions at the interim stage, especially when the expert hadn't been cross-examined. They also claimed it wasn't an expert's role to opine on inventive step, as that's a complex legal determination solely for the court. They even went so far as to assert he didn't have direct access to the Aladdin product itself when preparing his affidavit, relying only on specifications.
Finally, they raised the classic arguments of irreparable loss and the balance of convenience. These are fundamental injunction cases. They claim that granting an injunction would cause irreparable loss to defendant number 2 due to its established goodwill and market presence since 2020. They also pointed out that SML's own sales had, in fact, increased, suggesting SML wasn't actually suffering significant harm. Therefore, they argued, the balance of convenience lay with the defendants, and denying the injunction would serve the public interest by allowing competition in an essential commodity market.
And in a final sweeping claim, they accused SML of evergreening, a contentious practice where companies allegedly make minor changes to an invention to obtain new patents and extend their monopoly. They alleged SML willfully suppressed information about earlier patent applications for the same invention, pointing out that one was withdrawn and another, in 282429, was found prima facie invalid by the Delhi High Court in a separate interim order. This, they argued, implied SML was just tweaking ranges and refiling applications to extend its monopoly beyond the original patent term, an abuse of the patent system, they claimed.
This really raises an important question. When you look at the sheer breadth of these counterarguments, you can see how Mohan Company tried to frame every factual point within the strict legal definitions. The defense, in particular, really tried to poke holes in the very foundation of SML's patent's validity, even attempting to leverage significant public interest arguments to their advantage, all while trying to undermine the credibility of the plaintiff's key expert evidence. It was a comprehensive defensive strategy, hitting from multiple angles.
Okay, so after hearing these detailed and often intricate arguments, with each side presenting their best case, supported by technical data and legal precedents, what did Honorable Mr. Justice Sandeep Sharma decide? Here's where it gets really interesting, because the court had to carefully weigh all these complex points, from the nuances of chemical composition to the deep implications of legal history and public policy. The decision came down on June 6, 2025. The High Court of Himachal Pradesh confirmed the ex parte ad interim injunction that had initially been granted on July 24, 2023, in favor of SML Limited. This was a clear and significant victory for the patent holder at this crucial interim stage of the legal battle. It meant the court agreed that SML had a strong enough case to warrant continuing to block the sale of Aladdin.
Yes, but it's crucial to understand the very nature of this order. The court explicitly stated that its observations and findings were prima facie, meaning at first glance or on the face of it, and were intended only for the purpose of deciding this specific interlocutory or temporary injunction. This is not a final verdict on the ultimate merits of the case. That's a point the Supreme Court has time and again cautioned the lower courts on in intellectual property matters. It's a very important distinction that ensures the main trial remains uninfluenced by preliminary findings, allowing a full and fair hearing later.
That's a really important distinction for listeners to grasp. This isn't the final chapter, just a critical turning point, and the fact that the decision was officially approved for reporting indicates its significance as a legal precedent. It means this judgment will serve as a guide for how similar interim injunction applications will be handled in the future across Indian courts, giving it weight far beyond just this single case.
Regarding the core claim of infringement, the court found that Aladdin prima facie infringed claims 11 and 12 of SML's patent. This finding was overwhelmingly supported by Dr. Phul Kumar Patanjali's detailed, unrebutted chemical analysis. The court specifically noted that Aladdin's compositional characteristics, its precise sulfur, zinc oxide, and excipient content, as well as its granule and particle sizes, fell squarely within the precise ranges specified in SML's patent claims. The defense's attempts to discredit Dr. Patanjali's expertise and his analysis were ultimately not persuasive enough to rebut his scientific findings, leaving his evidence unchallenged in the court's eyes at this interim stage. Right. Moving to the patent validity argument, which was a major thrust of the defense, the court concluded that the defendant failed to raise a credible challenge to the validity of SML's patent. This was a major blow to Mohan Company, as successfully challenging validity is often the strongest strategy in an infringement case. The court essentially said their arguments weren't strong enough at this stage to shake the patent's presumed validity. On the Section 3 argument concerning the requirement for enhancement in efficacy for new forms of known substances, the court sided definitively with SML. It found that SML had indeed established a prima facie case for demonstrating this enhancement in efficacy. The court specifically highlighted that treatment number 7, representing SML's patented composition, showed a demonstrably higher yield compared to treatment number 15, identified as prior art. This yield increase was considered sufficiently significant to suggest an enhancement. And crucially, the court explicitly affirmed that yield improvements constitute a material parameter for assessing agricultural efficacy. This is a key aha moment for agricultural patent law. The court clarified that measurable crop yield increases can be sufficient proof of enhanced efficacy under Section 3, providing a clear pathway for agricultural innovations to meet this tough patentability standard.
And the court even shrewdly turned the defendant's own product packaging against them, noting that Aladdin's packaging highlighted improved features over conventional micronutrient source and its water-dispersible nature. The court saw this as a significant admission by the defendant that their product wasn't just old prior art, but an improved composition, which further supported SML's claim of a unique and inventive feature. It was like Mohan Company's marketing department inadvertently helped SML's case. Funny how that happens sometimes.
When it came to the credibility of the challenge and the 6-year rule for older patents, the court acknowledged that the 6-year rule is indeed a rule of caution, not a rigid binding rule, and that validity always depends on the specific facts of each case. However, the court found it highly significant that the defendants were already aware of SML's patent. Due to their prior participation in pre-grant and post-grant oppositions through their association HPMA, this wasn't some new discovery for them.
Yes. The court viewed the defendant's challenge to the patent's validity, which they only raised after the infringement suit was filed, as an afterthought. It's like trying to dispute a bill after you've already tried and failed to cancel the service twice. The court found their argument lacked genuine conviction and scientific basis at this interim stage. Crucially, the court emphasized that for a credible challenge to validity at the interlocutory stage, it requires acceptable scientific material supported by expert evidence. And the defendant, in this case, failed to provide that. Mere averments or simple assertions were simply not enough to sway the court or overcome the patent's presumed validity.
Furthermore, the court implicitly but decisively rejected the defendant's argument that the Essential Commodities Act and the Fertilizer Control Order override the Patents Act. The court's decision aligned with the plaintiff's rebuttal, that the FCO only sets minimum quality standards for fertilizers. It does not authorize infringement of a patented product or grant immunity from patent law. This is a vital point for balancing public interest with intellectual property rights, clarifying that meeting a regulatory standard doesn't grant a free pass to infringe patented technology.
Okay, and on the question of territorial jurisdiction, the court confirmed that it indeed had the authority to hear the case in Himachal Pradesh. It found sufficient evidence in an invoice showing a sale of Aladdin in Mathiana district Shimla, which clearly falls within the court's jurisdiction. This single transaction, even if orchestrated, was enough to establish a prima facie link.
The court also noted that defendant number 2's own brochure indicated a manufacturing unit in Una, Himachal Pradesh, which also falls within the court's jurisdiction, further supporting the plaintiff's claim that the defendants had a presence there. As for the trap purchase argument, the court wisely stated that this was a factual question to be determined during the full trial, not at this interim stage. They also pointed out the absence of not for sale markings for Himachal Pradesh on Aladdin packaging, despite the defense's assertions that they didn't sell there. Seems like a small detail, but potentially significant.
And finally, when assessing the balance of convenience, who would be more inconvenienced by a temporary injunction, and the risk of irreparable harm, the court found that these factors clearly favored SML Limited. Given the strong prima facie case of infringement and the defendant's outright failure to credibly challenge the patent's validity with solid evidence, the court concluded that the patentee, SML, was the one who would suffer more significant irreparable loss if the injunction were not granted.
So if we connect this judicial decision to the bigger picture, this ruling really underscores a few critical aspects of Indian patent law. First, it highlights the paramount importance of robust expert evidence, both in establishing infringement and perhaps even more significantly, in mounting a credible challenge to patent validity. Second, it clarifies that merely asserting a patent is old or that there were prior regulatory standards isn't enough to invalidate it, not without concrete scientific backing that meets a high evidentiary bar. And finally, the court's strong stance on upholding the patentee's exclusive rights, even at an interim stage, powerfully reaffirms that patents are indeed considered the highest form of monopoly, deserving of swift judicial enforcement when challenged.
So as we've established, this wasn't the final word on whether Aladdin permanently infringes SML's patent, but it's a huge, strategically important win for SML at this stage. What does this interim decision mean for patent law in India, and how might it influence future cases?
Well, as a high court judgment, this decision serves as a binding precedent for subordinate courts within Himachal Pradesh, and it carries significant persuasive value for other high courts across India. It's essentially providing a clear roadmap for similar disputes, offering clarity and consistency in judicial approach.
This decision provides important, clear guidance on how courts should approach applications for interim injunctions in patent cases. It reinforces that these aren't granted lightly, but also that they are a powerful, necessary tool when the initial evidence of infringement is strong. And, crucially, the validity challenge against the patent is weak or unsubstantiated.
Absolutely. And one of the most important takeaways from this judgment is its clarity on the credible challenge standard for patent validity. This decision emphasizes the absolute necessity for defendants to present scientific material and expert evidence if they want to successfully challenge a patent's validity at the interlocutory stage. Mere averments, vague claims, or simple assertions are simply not enough to overcome the presumption of validity, especially for an already granted patent that has survived prior challenges. This sets a very high bar for anyone trying to stop an injunction by claiming patent invalidity.
And the court's finding that yield improvement constitutes enhancement in efficacy for agricultural compositions under Section 3D is a particularly key interpretation. This provides a clear, measurable metric for proving an inventive step in this specific sector, guiding future patent applications and disputes concerning similar agricultural innovations. It's a pragmatic recognition of how innovation actually happens in agriculture.
The judgment also reinforces how territorial jurisdiction can be established in patent infringement suits in the modern interconnected market. Even a single trap purchase or the online availability of a product, coupled with other factors like a manufacturing unit within the court's jurisdiction, can be sufficient. It makes it clear that such strategic purchases don't automatically negate jurisdiction, which is crucial for patentees trying to enforce their rights against infringers operating across state lines.
And in a broader sense, this case further outlines the court's approach to balancing convenience and irreparable harm in patent matters. It reinforces the principle that when there's a strong prima facie case for infringement and a weak, unsubstantiated challenge to validity, the scales of justice tip decisively in favor of the patentee, acknowledging the significant investment and risk innovators undertake.
Fundamentally, the judgment strongly affirms the patentee's exclusive right under Section 48 as a highest form of monopoly, deserving of robust judicial enforcement, even at this interim stage. It sends a powerful message across the industry about the Indian judiciary's commitment to protecting genuine innovation and the rights of those who invest in research and development.
Right. And this judgment doesn't just stand alone as a new ruling. It extensively relies on and reinforces principles from several key Indian patent law precedents, truly weaving them into its fabric. Let's look at how the court leaned on established legal pillars.
For instance, the judgment cited Novartis AG and Anr v. Cipla Ltd. This isn't just a casual citation. This case is fundamental to understanding the nature of patent rights and the court's role in granting injunctions. Novartis v. Cipla emphasizes that courts must take a holistic view when deciding on interim injunctions, meaning a judge needs to look at the entire picture, the strength of the plaintiff's claim, the validity of the patent, the potential harm, the public interest, before making a decision. It underscores that it's not about isolated facts, but the overall strength of the case.
And the court strengthened the idea from Bristol-Myers Squibb Company Anr vs. J.D. Joshi, which states that old patents carry a presumption of validity unless controverted by strong evidence. This presumption played a big role here, as SML's patent was already 14 years old. It means the older your patent is, the stronger it's presumed to be, putting the burden squarely on the challenger to bring truly convincing proof of invalidity.
The decision also heavily leaned on Strix Limited v. Maharaja Appliances Limited, and this is a real game-changer for defendants. Strix Limited reiterates the critical requirement for defendants to provide acceptable scientific material, supported or explained by the evidence of an expert, to challenge patent validity at an interlocutory stage. What this means in practice is if you're an alleged infringer trying to invalidate a patent and avoid an injunction, you can't just make assertions. You actually need your own independent scientific proof, like test data, or a detailed expert report right there at the interim stage to show the patent is likely invalid. It says a very high evidentiary bar, and it clearly tripped up Mohan Company in this case.
And the court extensively cited Novartis versus Netco Pharma Ltd., which provided a comprehensive set of principles that have become essentially the playbook for judges deciding these temporary injunctions in India. This includes guiding principles on patentability. Is this truly an invention? Does it have novelty, inventive step, industrial applicability? Infringement determination. Did they copy it? This involves directly comparing the defendant's product against the patent's claims. Claim construction. How do we interpret what the patent really covers? Obviousness tests. Is this invention something any skilled person could have easily come up with? And even Section 8 compliance. Did the patentee properly disclose information about foreign patent applications? It's an all-encompassing framework.
It further affirmed Biswanath Prasad v. Hindustan Metal in making the 6-year rule for old patents a persuasive caution rather than a rigid binding rule. This means judges have discretion based on specific facts, and simply reaching that 6-year mark doesn't guarantee absolute validity, but it certainly strengthens the patentee's position. And it used SMPC Machines PVT Ltd. And Ors versus Mr. Vishal Chaudhry to support its finding on territorial jurisdiction. Confirm that even attempts to transact or online product availability can establish local jurisdiction in today's digital market, making it harder for infringers to hide behind geographical boundaries.
The judgment even drew on guiding factors from classic legal texts like Kerr on law and practice of injunction, highlighting situations where injunctions are typically granted. These include when a patent's validity has already been established or is not seriously an issue, or when the patent is of long standing and its enjoyment by the patentee has been uninterrupted. This aligns with the court's view of SML's patent as robust and previously unchallenged in specific ways.
So this judgment, approved for reporting, provides a robust roadmap for future patent infringement cases, especially at the critical interim injunction stage. It clarifies the high bar for defendants to successfully challenge a patent's validity, underlining the judiciary's commitment to protecting intellectual property rights in India. Simultaneously, it demonstrates how courts navigate complex issues like public interest and essential commodities, seeking to balance the immediate needs of patent holders with broader considerations of market competition and regulatory compliance. It's a pragmatic decision that offers valuable insights into the evolving landscape of Indian IP law.
What a deep dive, really. From specific chemical compositions and their precise particle sizes to the intricate nuances of legal precedent and the balancing act of public interest, we've seen how one patent infringement case, SML Limited versus Mohan Company, offers a profound look into the dynamic world of intellectual property. The High Court's decision to confirm the interim injunction wasn't just a win for SML, it was a clear statement on the stringent standards required to protect and challenge innovation in India.
Indeed. And while this was an interim order, a crucial and significant step in the ongoing legal process, it powerfully reinforces the principle that patent rights are a robust and enforceable form of protection under Indian law. It tells us that merely asserting invalidity or claiming a product as prior art isn't enough. You need strong, scientific, and credible evidence to stand up against a granted patent, especially one that has already survived multiple challenges. This case vividly highlights the constant tension between protecting the substantial investments made in innovation and ensuring access, particularly in vital sectors like agriculture.
So here's where it gets really interesting for you to consider as you think about this case. This case will now proceed to a full trial where the final determination of the patent's validity and infringement will be made. What further compelling evidence do you think the defendants could potentially bring to truly overturn the prima facie findings of this interim injunction? It's a high bar now. And how might future interpretations of public interest evolve in patent cases involving essential commodities? As this particular intersection continues to be a crucial point of debate in India's rapidly developing economy. Definitely food for thought as we continue to navigate the fascinating and ever-evolving landscape of law and innovation.